Hello, this is Kevin Stewart with Briggs & Maselka. I'm a principal within the advisory practice of Briggs & Maselka, where I lead a team in the client accounting services department, as well as technical accounting and internal controls. Today, we're going to give a little bit of an update on the PPP Flexibility Act. This is in addition to our other presentations we've given over the last couple of months, and it's really related to navigating the gray, meaning that there is still areas of interpretation within the PPP program. And so over the last several months, the Congress has responded with various legislation. The two areas in gray there of the Paycheck Protection Program and the PPP Flexibility Act are the two items that we're kind of following up on today. And so this is an ever-evolving process. What we knew 2 months ago as the PPP program was rolled out and people made their applications and we were trying to educate, that understanding has changed, and there have been multiple iterations of interpretation by the SBA, by the Treasury, and then subsequently by us as CPAs, accountants, and financial advisors. So what we're presenting today is what we know as of today, and some of it is based on our interpretation. So the path to forgiveness, the forgiveness is not guaranteed. We've kind of addressed that many times and consulted with clients over and over again. But that maximum loan amount is based on the qualified expenses, that have been incurred, non-qualified expenses, and then either excess funds. And so there may be some forgiven, some of that may be converted to a 2 to 5 year loan, or there's a portion of that may just need to be returned. So as the PPP forgiveness application timeline, it is something that you should be patient with, in that the application, upon receipt of the application by the lender, they have 60 days to approve forgiveness and process it and push it through to the SBA for their review. The SBA, once they received it and the lender makes their determination on the forgiveness eligibility, the SBA has 90 days to review the lender's determination. There may be some back and forth in there, and so that review period may be extended beyond 90 days. Once that application is approved and once that determination is made, then the borrowers must retain that PPP documentation for at least 6 years after the date the loan was forgiven or paid in full. Now, this is because the SBA has reserved the right, the Treasury Department has reserved the right to audit or review all applications. They have guaranteed that they will automatically review any loan at greater than $2 million, but there is a possibility that all loans may be reviewed. There is that potential. One thing it does not call out in any of the guidance we've seen is, can you apply for forgiveness prior to the end of your coverage period? Whether that be 8 weeks or 24 weeks. We don't know the answer to that. And we'll talk a little bit about that more in the next few slides. So as a point of comparison, pre-Flexibility Act and post-Flexibility Act is the loan term for all loans processed prior to June 5th was 2 years. So that 2 years can be extended to 5 years, but that would require some conversations with your bank and agreement. Post-Flexibility Act, that loan term is automatically 5 years. So post-June 5th funding, 5 years is the loan term. Covered period. Pre-Flexibility Act, 8 weeks is standard. So from the point of disbursement, you have 8 weeks to use the payroll proceeds and fund it. Post-Flexibility Act, you do have the alternative to choose. 8 weeks to 24 weeks, but there is a time period there as well, a date of after a certain date. That 24 weeks is just assumed. Payroll costs needed. 75% was previously, 75% would be paid for payroll cost, and then 25% would be for the allowed non-payroll cost. Post-flexibility, 60% is the allowance. Safe harbor date, that really should be up to June 30th and up to December 31st. Again, that is both driven on the date of disbursement and the 8 or 24 weeks prior to that period. So meaning that if you bring your employee levels, FTE levels back up to close to your original levels, then that is a safe harbor date as of those specific dates. Again, 8 to 24 weeks after the disbursement date. There were some exceptions at the beginning related to FTEs. If somebody was fired for cause or if somebody voluntarily resigned and you were unable to replace, then there would be some exceptions there. There have been some added exceptions for employees no longer available within the Flexibility Act. That may specifically relate to employees that have moved to, that they've been laid off or furloughed, and so they're getting benefits through unemployment. And so maybe they choose not to come back because it's more beneficial for them to obtain the unemployment. In certain situations, maybe an employee has retired, and so rather than replacing them, it did not make sense to replace them, then there would be some exceptions related to that as well. So getting into really the specific areas of gray here is the PPFA, changes amount of loan needed for payroll from 75 to 60%. There was, based on the original strict reading, that 60% seemed to be a cliff, but based on some guidance that was released today, that is no longer the case. So the gray is determining whether to use either the 24 or 8-week time period, and what makes the most sense for you as a business. Second, there is the PPPFA, extends time period to use funds from 8 to 24 weeks. The annualized income of $100,000 is still relevant. I believe under the 8-week period, it's $15,500 and change is that dollar amount. Under the 24-week period, I want to believe it's in the $46,000 range. So that annualized income amount is based on the period that you choose. So that income level, annualized income level, is still relevant. The gray area is really about the subjectivity in determining which time period is most beneficial to you, the borrower. Extending out to the 24 weeks may make sense for you, right? If you haven't been able to use the funds entirely, and it would be beneficial to your employees and to your business. But are borrowers allowed to submit their application before the 8 or 24-week covered period? The answer is we don't know. The guidance seems to say no, but it's hard to determine when the application is allowed to be made. As it relates to FTE and safe harbor changes, there are rehire dates. It's not later than December 31st, but as mentioned earlier, it is really specifically driven off the disbursement date. So that 8-week coverage period determines when that FTE safe harbor is. Same thing for the 24-week period. But the question becomes, what if the borrower meets the requirements on July 15th, but then it doesn't meet it on August 1st? The answer is we don't know. I think there's still some guidance there that needs to be made, specifically as it relates to the application process. Once you use the funds, it would make sense to be able to apply for forgiveness at that point. But the guidance doesn't really clearly state if that's truly allowed. Easing of the rehire requirements. So the borrower can still qualify for forgiveness if it can, as it notes here, document an inability to return to the same level of business activity. Now, it specifically kind of calls out forced closures, social distancing, business operation levels that were made required by the HHS, CDC, and et cetera. The gray area really is, while some borrowers will clearly be able to meet this requirement, for others really introduces a level of risk, a certain amount of subjectivity that you may not put reliance on. Was the business change due to the social distancing? Was it due to HHS, or was it something else? Was it because some unrelated consequence that is hard to justify? So there becomes a question of, does this level of subjectivity, can you rely on this in case you haven't been able to restore levels of FTE levels? Extended term, 2 to 5 years. And this really kind of goes to the pre-June 5th loans, right? So can you push it to 5 years from 2 years? And it really becomes an area of negotiation with your lender. The original loan agreement was for 2 years. That's the agreement that you signed. To push that out to 5 years will require an extension with your extension of terms with the bank. And will it make sense for the bank to do that because there's no increased cost, no increased fees, and yet the servicing period will last an additional 3 years? So those are some things to be addressed. So as always, we have a resource page. Within the links of this document, we do have resources by which you can use. Historical webcasts that we've posted, or our presentations that we posted, and many other pieces of information. As always, it's a pleasure to be able to present this information to you. We hope that you found it useful, and if you have any questions, please feel free to reach out to the email below at the SBA assistance at bbccpa.com. And we will gladly get back with you as soon as we can. Thank you.